So in the last class, we were discussing that we had submitted the documents related to Memorandum of Association, electronic documents, Memorandum of Association, Articles of Association, and other documents required for the process of incorporation. Now we shall be starting with obtaining certificate of incorporation. After verifying all the documents and information submitted to it is proper, the register of the companies will enter the name of the company in the register of companies and certifies under his hand that the company is incorporated. Registrar issues the certificate of incorporation in the prescribed form. Now, contents of certificate of incorporation: the name of the company, date of issue of certificate of incorporation, CIN, uh, PAN and TAN of the company, the signature of registrar with the date and his seal. So the certificate of incorporation is submitted. Once all the proper documents and information whichever is asked by the registrar is being submitted, then the registrar of companies will enter the name of the registrar or name of the company in the registrar, then certifies under his hand that the company is incorporated. Then registrar issues the certificate of incorporation in the prescribed form. Then what are the contents of the certificate of incorporation? The name of the company, date of issue of a certificate of incorporation, then CIN, PAN and TAN of the company, signature of registrar with the date and his seal. So these are after this. Now what is the importance of certificate of incorporation? Certificate of incorporation is like the birth certificate of the company, as the company comes into existence from the date mentioned in the certificate. The company now becomes a legal person distinct from its members. Company becomes a body corporate having perpetual succession from the date of its incorporation. The company can sue and be sued upon in its own name. So then the certificate of incorporation is like the, what is the importance? It is like the birth certificate of the company, and after that the company comes into existence from the date mentioned on the certificate. It becomes a distinct person and having a perpetual succession from the date of its incorporation, and the company can sue and be sued upon in in its own name also. So this is the certificate of incorporation. This is how the certificate looks like, in which it is written Government of India, Ministry of Corporate Affairs, Central Registration Center, Certificate of Incorporation. Then it is certified that this company is incorporated on the day of this of 20,000, whatever is the year, and under the Companies Act 2013, and that the company is limited by shares. The corporate identification number of the company is, the permanent account number of the company is this, tax deduction and collection account number of the company is dash, given under my hand at this of this day of the month 20,000, then 2000, then digital signature certificate on behalf of the judicial registrar of companies, and this so this is how the certificate of incorporation looks, and mailing as address as per record available in register of companies. Now next we have allotment of corporate identity number, CIN. At the time of issuing certificate of incorporation, the ROC also allots a CIN to the company, which is the unique identity number. CIN is a 21-digit alphanumeric code and is to be quoted in every form and correspondence that the company uses. CIN, corporate identity number, issued by ROC at the time of incorporation of a company. It indicates whether a company is listed or unlisted, industry code, state of its location, year of incorporation, ownership type, and registration number. So, it is very important to have a corporate identity number, which the ROC allots, and it is a unique 21-digit alphanumeric code and is quoted in every form and correspondence of the company uses it. Then after this we have additional information. So how is the corporate identity number given? So in that, see, the company that they have given, for example, is Tata Steel Limited. CIN is L2700 MH1907 PLC 00260. So L is listed or unlisted company. Then 27100 is industry code. MH is state code of ROC. Then 1907 year of incorporation. Then PLC type of company, that is public company, private company, or OPC. Then ROC is registration number. So this is how a unique identification number is given to every company. Similarly, you can find out these all companies which are given by them. For example, this activity you can try to solve and understand that which CIN is given to which kind of company. So in this we can say that the first company which is given is an unlisted company, and it is in Tamil Nadu. Then it is OPC. It is formed in 2014, OPC, and it is type is OPC. Then the second one is a listed company. It is in and Maharashtra, and it is a PLC. PLC means a public limited company. Then third one is an unlisted company which is situated in Karnataka, or with the incorporated or the state. Then PTC, that is private company, and it is formed in the year 2003. So this is how a CIN is given to different companies. Now we have studied two steps. First is the promotion stage, second is the incorporation stage. Now we shall be starting with the third stage, that is the commencement of business. Public companies and private companies not having a share capital can commence its business activities immediately after it has received the certificate of incorporation from the Register of Companies. However, public companies and private companies having share capital and which are incorporated after 2nd November 2018 have to obtain certificate of commencement of business from the Register of Companies before it can commence its business activities for exercise activities or exercise borrowing powers. So commencement of business, the if whether it is a public company or private company, or not having share capital, can commence its business activities immediately after it has received its certificate of incorporation from the Register of Companies. Then public and private companies having share capital and which are incorporated after 2nd November 2018 have to obtain a certificate for commencement of business or from the Registrar of Company before it commences with its business activities. So what are the process to obtain certificate of commencement of business? In that, first we have filing of declaration by director. A director of a company has to file with the ROC a declaration in the prescribed form along with fees. The declaration states that every subscriber to the memorandum has paid the value of the shares agreed to be taken by them. The contents of the declaration shall be verified by a company secretary in practice, or a chartered accountant or a cost accountant in practice. The declaration should be filed within 180 days from the date of incorporation of the company. So a director can file with ROC the declaration with the prescribed form and the fees. Then a declaration states that every subscriber has paid the value of the shares agreed to be taken by them, and the declaration shall be verified by either a company secretary or a chartered accountant or a cost accountant, and it should be filed within 180 days from the date of incorporation of the company. Then file verification of registered office. Company has to file a verification of its registered office with the ROC. Then next it has to obtain license or approval from secretarial regulator. Certain companies which propose to conduct banking business, insurance business, or propose to be listed on stock exchanges required registration from secretarial regulators like Reserve Bank of India, Securities and Exchange Board of India, etc. Such companies must submit to ROC the approval obtained from the secretarial regulator. So now they have to obtain a license from a sectoral regulator, and those business who propose to conduct banking, insurance, or to be listed on stock exchange, they require registration, and such company must obtain approval to submit to the ROC, and obtain approval from the sectoral regulator. So this is the third step for obtaining license or approval from the regulator. Now, who is a sectoral regulator? Are regulators appointed by the government to regulate a particular sector. Example: SEBI is a regulator of securities market. After this, the last step, which is commencement of business. After filing declaration in the prescribed form, the ROC then shall issue certificate of commencement of business. Public and private companies having share capital can now start its business, or start collecting or borrowing money to undertake its business activities. A public company issues prospectus to the public. Prospectus is an invitation to the public to buy the shares of the company. So in this process, we have formed a company, and we have started with the company. So this with this we complete the third chapter from our syllabus, that is formation of a company. So you can go through the chapter, go through the all the objectives, and we shall see with the next chapter after this. Now we shall start with the next topic. Now next we have documents related to formation of the company. Now we shall be studying about the three most important documents of the company, which is memorandum of association, then articles of association, and prospectus. So these three documents we shall be studying each of them in detail. So let's start with the fourth chapter. Introduction. At the time of incorporation of a company, following documents have to be submitted to the Registrar of Companies: Memorandum of Association, Articles of Association. A public company, if it is collecting capital from the public, must issue prospectus to invite the public to buy its shares, debentures, etc. Let's learn in detail about these documents in this chapter. Memorandum of Association. Now we shall be starting with the first document, that is Memorandum of Association. It is a primary document of a company as it states the purpose for which the company is formed. It describes the range of activities of a company can undertake. Definition. Section 256 of the Companies Act 2013 defines memorandum as memorandum of association of a company as originally framed or as altered from time to time in pursuance of any provision of any previous law of this act. The above definition refers to memorandum of association as a legal document that must be prepared by every company as per the provisions of the Companies Act 2013. So memorandum of association is originally framed or altered from time to time in pursuance, that is with the changing provisions of the company law, or as per the act makes changes in their documents. So memorandum of association is a legal document, and that must be created by every company as per the provisions of Companies Act 2013. Lord Cairns, the Memorandum of Association of the company is its a charter, and defines the limitation of the powers of the company. As per this definition, memorandum is a document which describes the constitution of the company and its rights or privileges. It states the powers of the company, that is what it can do and what it cannot do. So memorandum means it is a clearly a charter or defines the limitation of the powers of the company. So memorandum is a document which describes the constitution of the company, its rights and its privileges, and it also states what powers it has and what a company can do and what a company cannot do. Next, we have features of memorandum of association. It is a primary document of a company which states its aims and objectives. It describes and regulates the relationship between the company and the outsiders. So, it is a primary document which states the aims and objectives of the business. Firstly, then it describes and regulates the relationship between the company and the outsiders. Outsiders who are considered as outsiders in case of memorandum. So, firstly, shareholders, then creditors, suppliers, investors, etc., who can make out from the memorandum whether a company is permitted to undertake a certain activity or not. Every company needs to prepare its memorandum of association at the time of its incorporation and submit it along with the application for incorporation of the ROC. It is prepared by the promoters and needs to be signed by minimum 7 persons in case of a public company, 2 persons in case of a private company, and 1 person in case of a one-person company. So, promoters need so it is needed to be signed by minimum 7 persons in case of a public company, 2 persons in case of a private company, and 1 person in case of OPC. Each subscriber must write against his name the number of shares he has agreed to subscribe. As per the Companies Act 2013, each subscriber must take at least one share. This will not be required for a company with a guarantee without share capital. So, whatever shares has been taken by the promoters, they have to write their name and the number of shares they have agreed to subscribe. So, these all things should be mentioned in the memorandum of association. It contains following clauses. Firstly, the name clause. Then second is the address clause. Third is the object clause. Fourth is the liability clause. Fifth is the capital clause. Sixth is the association or the subscription clause. So these clauses shall help in getting proper information regarding each of the aspects of a company. Sixth one, as it defines the nature and character of the company, it is not so easy to alter the clauses. The Act has laid down specific rules and provisions to be followed to alter each clause. It cannot contain anything contrary to the provisions of the Companies Act 2013. Any act done by a company which goes beyond the powers will be ultra vires, that is, it will be invalid. So, it defines the nature and the character of the business, and it is not easy to alter the clauses which are mentioned above. So, it cannot contain anything contrary. That is, whatever is mentioned in the Companies Act, only that can be mentioned in the Memorandum of Association. Anything which is mentioned beyond the powers of the memorandum, it will be considered as invalid. That is, ultra vires. It is a public document, and anyone who wants to enter into a contract with the company is supposed to have knowledge about the contents of a company's memorandum of association. So it is a public document, and anyone who wants to enter into a contract with the company is supposed to have knowledge of the contents of the company's memorandum of association. Then, Companies Act 2013 has prescribed the format in the form of table A, B, C, D, and E for preparing the memorandum for different type of companies. So, a format has been prepared, and table A, B, C, D, and E are for the different types of company, and they have given additional information regarding each of the table. So, table A, Memorandum of Association of Company Limited by shares. Table B, Memorandum of Association of a company limited by guarantee and not having share capital. Memorandum of Association of a company limited by guarantee and having share capital. Memorandum of Association of an unlimited company not having share capital. Memorandum of Association of an unlimited company and having a share capital. So these are the different tables which are given and which give different information related to share capital. Then next we have each of the clause and how each of the clause is functioning. So first is the name clause. We shall be studying about the name clause first. The clause mentions the name of the company. As a company is a legal entity distinct from its members, it has to have its own name to establish a separate identity. Uh, the promoters choose a name of the company. The following points should be kept in the mind while choosing the name of the company. The name should not be identical or reasonable to the name of an already existing company registered under the this act or any previous company law. So firstly, the name should not be any identical name or should not resemble any of the name which is already existing or existing under any previous company law. Then next, the name should not contain any words which will constitute any offense of any law. The name or words in the name shall not offend any section of people. The name shall not violate the provisions or of emblems and names prevention of improper use act 1950. The name shall not resemble any registered trademark. The name should not have any word that gives an impression that the company is connected with or has the support of central government or any local authority. In case of a public limited company limited by shares or guarantee, the last words of the name should be limited. Example, Tata Steel Limited. Similarly, of a private company share by shares or guarantee, the last words of the name should be private limited. Example, POSCO India Private Limited. And in the case of one person company must be mentioned in the name of the company in bracket. Example, Smart Services Private Limited, OPC. The Companies Act states that every company shall paint or affix its name and the address of its registered office outside its place of business. So basically, the name clause states that firstly, a name shall be chosen in such a way that it should not be already existing. Then secondly, the it shall not constitute an offense of any law. It should not offend any section of the people. Then it should not violate the provisions of emblems and names act. Then it shall not resemble any registered trademark. Then the name should not have the words that give company the impression that it is connected or it has the support of either central government or state government or any local authority. Then public company limited by shares or guarantee, the last word shall be limited. Example, Tata Steel Limited. Then if it is a private company, then in that case it shall have private limited written. Then if it is a one person company, it shall have OPC in the bracket, and it shall be properly painted or affixed at the registered office outside its place of business. So this is about the name clause. Now, in case we want to alter, that is make changes in the name clause. So for that purpose, a company may change its name anytime on its own, on its conversion from public to private or vice versa, on the direction of central government, if it is of the opinion that the name of the company is similar to the name of an already existing company or similar to a registered trademark. Name clause can be altered by passing a special resolution in the general meeting of a company. Special resolution means 3/4 or 75% votes are in favor of the proposal. So alteration in that case, either it can be altered on its own or it can be conversion from a public to a private or vice versa. Then on the direction of the central government, it is of the opinion that it is the name is already existing or the similar company or a similar registered trademark, or if the central government has made it compulsory for the change. In case a name clause is case the name clause is to be altered, in that case a special resolution is to be passed in the general meeting of a company, in which a three-fourth or 75% of the votes are in the favor of a proposal. So this was about the name clause. Now next we shall be starting about the address clause. First was the name, second is the address clause. The address clause, registered office clause. The clause states the name of the state in which the registered office of the company will be located. Every company must have its own registered office within 30 days of its incorporation. A registered office is a must as it establishes a domicile location of a company. It is the address of which all communications, notices, etc. will be sent. It is also the place where all statutory books, records, and documents of the company will be kept. The address clause also indicates the jurisdiction of the court where cases can be filed by the company against the others. So, firstly, address clause is important because it obtains a proper location of a company. Then, it is also used for sending communication or notices that either public or the government has to send, or the registered office has to send. Then, it also has a place where all statutory books of records, documents will be kept. The address clause also indicates the jurisdiction of the court. In case a company is to be sued or a person is going to sue a company, in that case, the jurisdiction of the court is also very important in case to file cases against the company, or for the company to file against people. So it also helps for the jurisdiction of the court. Then, in case you want to make alteration of the address clause, in that case, a company may change its registered office from one place to another place within the same city or town. In this case, no alteration is made in the memorandum. One town or city to another town or city within the same state, one state to another state. In both the cases, B and C, a special resolution is passed in the general meeting to alter the address clause. In case of C, above approval of regional director is required. So, in case of alteration, there in case of alteration, in the cases of B and C, a special resolution is passed in the general meeting and alter the address clause. And in case of C, above approval of the regional director is required. So this was the clauses related to address clause. Now in the next class we shall be starting with the objects clause.